Imagine this. You're 78 years old. You live alone. Your daughter calls you 3 times. No answer. She calls again. Still nothing. So she calls the police and says, "I'm worried about my father. Please check on him." A few minutes later, police officers pull up outside your house. They knock. Nobody answers. They knock again. Still nothing. Then one officer says, "We need to make sure he's okay." And suddenly you hear a loud crash. The door comes down. Police are inside your home. But here's the question almost nobody thinks to ask: can they legally do that? And the answer is not. Simply yes. It's also not simply no. The real answer depends on something much more important. What did the officers reasonably know before they entered? Because a welfare check is not a magic phrase that gives police unlimited power to enter someone's home, and the Supreme Court has made that distinction extremely important. So stay with me, because by the end of this video, you'll understand exactly when police may be able to enter during a senior welfare check, when that entry can become unconstitutional, and what you or your family should do if officers show up at the door. The home is different. Let's start with the most important rule. Your home receives some of the strongest protection under the Fourth Amendment. Police generally cannot simply walk inside because they want to check something. They normally need a warrant, consent, or a recognized exception to the warrant requirement, and that's where welfare checks become complicated. Because police officers don't only investigate crimes, sometimes they're called because someone may be injured, unconscious, suicidal, missing, or otherwise unable to call for help. That's where the emergency aid exception can become important. The Supreme Court has recognized that officers may enter a home without a warrant when they have an objectively reasonable basis for believing someone inside is seriously injured or in imminent danger. So if police genuinely believe a senior has fallen inside the house and may be unable to reach the phone, that can be very different from an officer saying, "We're here for a welfare check, so we're coming in." Those are not the same thing. The Supreme Court case that changed the welfare check argument, one of the most important cases here, is Caniglia v. Strom. The case involved a man whose wife called police after a serious argument and became concerned about his safety. Police responded. The officers eventually removed him from the home and seized his firearms. The lower court relied on something called the community caretaking doctrine. But in 2021, the Supreme Court unanimously rejected the idea that this doctrine creates a freestanding exception allowing warrantless searches and seizures inside homes. The court made an important distinction. Police may perform community caretaking functions, but that does not automatically give them a license to enter someone's house without a warrant. That distinction is huge, because imagine an officer saying, "Don't worry, we're not investigating a crime, we're just checking on him." That statement by itself does not answer the Fourth Amendment question. The officers still need a lawful basis for entering, but there's an important exception now. Here's where we have to be fair. Imagine officers receive a call saying, "My 82-year-old father normally answers every morning. He hasn't answered all day. His phone goes straight to voicemail. His car is in the driveway. Nobody has seen him." Police arrive. They knock. They yell, "Sir, are you okay?" Nothing. They look through a window and see someone lying motionless on the floor. Now the situation has changed dramatically. The officers aren't just curious anymore. They have specific facts suggesting that someone inside may need immediate medical assistance. That is the kind of situation where the emergency aid exception can permit a warrantless entry, and there's a very important 2026 Supreme Court decision you should know about. It's Case v. Montana. The court reaffirmed that officers can enter a home without a warrant to provide emergency aid when they have an objectively reasonable basis for believing someone inside needs that assistance. The court specifically rejected the idea that officers need the same probable cause standard used in ordinary criminal investigations for this emergency aid situation. So yes, sometimes police really can break down the door, but the reason matters, the facts matter, and what they reasonably knew before entering matters. Here's where seniors become especially important. Justice Kavanaugh's concurrence in Caniglia gave an example that is almost exactly the situation we're discussing. Imagine an elderly man who is suddenly absent from his normal routine. His family cannot reach him. He doesn't answer repeated phone calls. Officers go to his home. They knock. Nobody responds. Under those circumstances, the possibility that the elderly person has fallen and suffered a serious injury can provide an objectively reasonable basis for emergency entry. Think about what that means. The police aren't allowed inside simply because he's old. Age alone is not the magic word. The question is whether the surrounding facts create a reasonable basis to believe someone inside may be seriously injured or in danger. That's the difference. 3 different welfare checks. Let's make this extremely simple. There are 3 situations you need to understand. Number 1, the officer is just curious. Imagine someone calls police and says, I haven't seen my neighbor in 2 days. Police show up, they knock, nobody answers. But there are no signs of an emergency, no screams, no visible injury, no report of a medical crisis, no information suggesting immediate danger. That is a much weaker basis for forcing entry. A welfare check label by itself doesn't erase the Fourth Amendment's protection of the home. Caniglia is particularly important here. Number 2, there are warning signs. Now change the facts. The senior normally calls his daughter every morning. He suddenly stops. His phone has been ringing for hours. His medication is sitting outside. A neighbor says they heard a crash. The family tells police he has serious mobility problems. Now officers have much more information. They may reasonably believe something is wrong. And that can strengthen the emergency aid justification. Number 3, there's an obvious emergency. Now imagine officers arrive and hear someone screaming inside, or they see someone collapsed through a window, or they receive reliable information that someone inside has suffered a serious medical emergency. That's an entirely different situation. At that point, waiting for a warrant could potentially put someone's life at risk. The Supreme Court's emergency aid cases recognize that officers don't have to stand outside waiting while someone suffers a serious injury inside. But here's the part most people miss: even when police lawfully enter for emergency aid, that does not automatically mean they can search every inch of the house for anything they want. The purpose of the entry matters, the scope matters, and the emergency matters. The Supreme Court's 2026 Case v. Montana decision emphasized that an emergency aid entry does not provide a basis to search beyond what is reasonably needed to deal with the emergency while maintaining officer safety. That's a critical distinction. If officers enter because they reasonably believe a senior has fallen, they're there to find the senior and address the emergency. That doesn't automatically turn the welfare check into an unlimited criminal investigation. So what should you do if police are at your door? First, stay calm, do not start yelling, do not physically block officers, do not threaten them, and don't make sudden movements. Instead, communicate. If you're inside and you're okay, one of the simplest things you can do is make that fact clear. Say, I'm okay, I don't need medical assistance. If appropriate, you can ask, do you have a warrant? And if officers say they believe there is an emergency, don't physically resist them. Remember, objecting verbally is very different from physically resisting. If they enter anyway, don't turn a legal dispute into a physical confrontation. If you believe the entry was unlawful, document what happened afterward and speak with a lawyer. In your state, if you're the family member WHO called, this is where things get even more interesting. If you're calling police for a genuine welfare concern, give them specific facts. Don't just say, I'm worried. Tell them why. For example, my father is 81. He normally answers every morning. He hasn't answered for 12 hours. His phone is ringing inside. His car is in the driveway. He has a medical condition. The neighbor heard something fall. Specific facts help officers evaluate whether an actual emergency may exist. And if you know the person is safe, tell police that too. The more accurate information officers have, the better they can assess the situation. The biggest myth: here's the myth I want you to remember. Welfare check means police can enter. No, that's too broad. A welfare check is a reason police may respond to someone's home. It is not by itself a blanket constitutional exception to the warrant requirement. Caniglia v. Strom is important precisely because the Supreme Court rejected a standalone community caretaking exception for warrantless home searches and seizures. But emergency aid is different. If officers have an objectively reasonable basis to believe someone inside needs immediate assistance, the Fourth Amendment can allow a warrantless entry. Brigham City and the Supreme Court's 2026 Case v. Montana decision are central to that principle. Here's the scenario I want you to remember. Imagine your 79-year-old father lives alone. You call him, no answer. You call again, nothing. You ask a neighbor to knock. Nobody answers. The neighbor says the curtains haven't moved all day. Police arrive. They knock. No response. Now ask yourself, what do the officers actually know? If that's all they know, the constitutional analysis may be very different from a situation where officers see the senior collapsed on the floor or hear someone calling for help. The details matter, the facts matter, and the legal justification matters. The bottom line: so can police legally break down your door for a welfare check on a senior? Sometimes, but not simply because they call it a welfare check. A home is strongly protected by the Fourth Amendment. Caniglia v. Strom says there is no standalone community caretaking exception that gives police unlimited authority to enter homes, but the emergency aid doctrine can allow a warrantless entry when officers have an objectively reasonable basis to believe someone inside needs emergency assistance, and the Supreme Court reaffirmed that principle in Case v. Montana in January 2026. So remember these 4 words. Welfare check is not permission. The facts surrounding the check determine whether a warrantless entry may be justified. And if police enter your home, don't physically resist. Stay calm, ask questions when safe, document what happened afterward, and if you believe your constitutional rights were violated, talk to a qualified attorney in your state, because the Fourth Amendment protects the home for a reason, and knowing the difference between a genuine emergency and a simple welfare check could make a huge difference. If you want the next video in this series, I'm going to break down another question that catches homeowners off guard. What happens when police say, "We're just here to talk"? Because that conversation can go somewhere very different from where you think it's going. Subscribe so you don't miss it.